It is an absolute pleasure to address you today. I'd like to begin by acknowledging the Ngunnawal people, traditional custodians of the land from where I'm joining you, and pay my respects to their elders, past and present. I also acknowledge our First Nations youth, in whose hands is held our hope as a nation for a reconciled future. I extend that respect to all Aboriginal and Torres Strait Islander people joining us. This vast continent of Australia is privileged to be home to the oldest continuous cultures on the planet. 2020 has been a year where we have all been faced with extraordinary challenges and sacrifices. We've faced storms of all kinds, fires, floods, and of course the COVID-19 pandemic. Some of us have been isolated from family and friends. Some have lost their livelihoods. Some have lost their lives. But Australians have pulled together to weather the COVID-19 storm, and now national attention is turning to rebuilding our economy. Lawyers, whose practical advice and expertise is critical to helping Australians stay on their feet through such crises, will play their vital part in this rebuilding effort. We at the Law Council of Australia consider that this moment presents a unique opportunity for Australians to broaden the conversation on survival. Being prosperous is one thing, but how do we as a society uphold and enshrine our core democratic values of freedom, fairness, and equality before the law? This is why now is the time to reignite the national conversation on a federal human rights charter, an issue which is bigger than any single government or political party. As you'd expect from a mob of lawyers, the Law Council looks to the legal infrastructure we have in place to pass on to future generations, not only the economic infrastructure. That brings us to the fact that Australia is the only Western democracy without some form of a Charter of Rights at the national level, whether legislated or by Parliament or entrenched by Constitution. And while on one hand, we can be proud of the way Australians have pulled together to weather the COVID-19 storm, we must be careful to avoid an erosion of the rights and freedoms that my father and his parents' generation fought for, and that Australians have had the luxury of taking for granted. In the 21st century, we have witnessed the backsliding of basic civic freedoms and democratic rights in this country. At a time of global power shifts, increasingly fragmented and insular national politics, and events characterised as profound blows to fundamental freedoms worldwide, the Law Council believes it's time to consider Australia's renewed commitment to the fundamental, universal norms of human rights, born out of the horrors of World War II. The Law Council recently released a refreshed policy on a Federal Human Rights Act. Our earlier policy is now 12 years old, and in the intervening period, there have been significant political, legal, and policy developments necessitating its review. The refreshed policy promotes a legislative model of human rights protection as a first step in achieving a constitutional model. And it's the Law Council's long-standing position that guarantees of human rights should be included in the Commonwealth Constitution. And the Law Council believes that having a Federal Human Rights Act in Australia will go some way to protecting vulnerable and abused Australians, including many people living with disabilities. There's little doubt that an implementation of a Federal Human Rights Act would improve the experience of people with disability, whether they're interacting with the civil or the criminal justice systems. While much of the applicable laws are state and territory based, the implementation of a federal act will nevertheless lead to an improved national culture of respect for the human rights of people living with disability. A Federal Human Rights Act would encourage and emphasise a human rights-based approach to the provision of services, as well as law enforcement, including in policing, and help to identify the changes needed to the culture and attitudes within various agencies. In turn, This may facilitate the improvement of prison conditions and access to services for people with disability, including inside and outside the prison context, including preventative, diversionary and rehabilitative services, which are funded by the Commonwealth as well as by state and territory governments. So to date, 2 Australian states and 1 territory have a Human Rights Act. The Australian Capital Territory, Victorian and New Queensland legislation primarily guarantee civil and political rights, including cultural rights, embracing the distinctive rights of Indigenous peoples. Some jurisdictions extend to protecting certain economic, social and cultural rights, such as the rights to education, as included in the ACT in Queensland, the right to work, ACT, and the right to access health services without discrimination, and not to be denied access to emergency medical care, Queensland. These jurisdictions give us insight into how that kind of legislation works in practice. While Queensland's legislation is relatively new, the ACT statute has been in place for 16 years and Victoria's for 12 years. We can also look to comparable jurisdictions overseas, such as the United Kingdom, Canada and New Zealand, and draw from the lessons learned so far in those nations. So why call for a Federal Human Rights Act? Let's look at 2 scenarios which the Law Council believes illustrate the need for a Federal Human Rights Act. Firstly, the COVID-19 pandemic, which has engaged multiple human rights in many different dimensions in Australia, from lockdowns to travel restrictions to tracing apps to mandatory quarantine and emergency health plans. Many Australians believe that their rights are already protected, that we already have a Bill of Rights similar to that in the United States. But in truth, our Constitution protects very few rights. And Australians would be surprised to learn that the rights which have been so hotly debated during the pandemic are in fact backed by very few constitutional or statutory guarantees. And currently, there's a disconnect between Australia's obligations at international law and their translation into Australian domestic legislation, which is where they become enforceable. So although we've signed on to these covenants, we can't enforce them. Take one example, quarantining arrangements. These interfere with rights recognised under international law, such as the rights to freedom of movement, security of the person and freedom from arbitrary detention, and the right to non-interference with privacy, family or the home. At the same time, they're intended to preserve other rights, such as the right to life, the right to the highest attainable standard of physical and mental health. The current federal legal framework of protection is limited and fragmented. Against this backdrop, who can blame individuals for becoming confused? The pandemic illustrated a need for a greater understanding that multiple rights may be at play in any given situation, and that tensions can and do arise between conflicting rights, which must be resolved. Specific rights are sometimes asserted by members of one part of the community to the detriment of the rights of others. For instance, some may say that the requirement for quarantining following travel infringes their freedom of movement or freedom from arbitrary detention. However, there may not always be a full appreciation that the broader community has rights to health and life, which governments and lawmakers under international law are obliged to respect, protect and enable. A human rights charter may assist public acceptance of government decision-making processes, including for decisions which must be made against rapidly unfolding circumstances. It would provide a much-needed established framework setting out the core principles to resolve tensions which arise when rights do come into conflict. So that's one scenario. Another is the spate of much-needed royal commissions established by successive governments. They've been called in response to, and have confirmed in graphic detail, a series of systemic and sometimes harrowing breaches of the human rights of diverse groups of Australians. there remains an urgent need to address the evidence received by and the findings of these commissions. This includes, of course, the Royal Commissions into violence, abuse, neglect and exploitation of people with disability, which has revealed stories of widespread use of restrictive practices in group homes for people with disability. The Royal Commission highlighted instances where preventative safeguards were inadequate, absent, or simply not being observed. In the Law Council's view, an improved anti-discrimination law framework, including the introduction of positive duties, as well as the adoption of a Federal Human Rights Act, would help foster ongoing attitudinal change to ensure that never happens again. We also feel that peak body forums are well placed to allow best practice approaches to be shared and improve government procurement practices which give weight to organisations which employ people living with disability. Royal Commissions, while welcome and necessary, are reactive, crisis-driven and highly resource-intensive policy tools. Further, as we all know, the recommendations of Royal Commissions are not always implemented fully, if at all. The Law Council considers that having a Federal Human Rights Act provides an excellent preventative measure and may negate the need for so many expensive and resource-intensive Royal Commissions. We're not suggesting that a Human Rights Act is an instant cure for all social ills. However, a human rights ethos established across the public and private sectors, across aged care, disability services, childcare, education, detention and health facilities, may curb the systemic need for what can seem like almost rolling Royal Commissions, investigating complex, wide-ranging social justice failures in Australia. Let's not forget that Australia is the only Western democracy not to have a Human Rights Act or some form of broad statutory or constitutional human rights protection. Countries with whose political systems we tend to identify most closely, such as Canada, New Zealand and the United Kingdom, all have some form of established human rights protection and an associated jurisprudence upon which Australian courts already draw. It's always difficult to know where to start and where to finish with the history of international human rights instruments. Suffice to say that Australia played a big role leading up to the adoption by the General Assembly of the United Nations of the Universal Declaration of Human Rights on the 10th of December 1948. We ratified the two major covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights in 1980. On the international stage, we seem to have been part of the leadership group. It's only at home that we seem to drag our feet. The promises we made in that process are encapsulated in the words of Article 2 of the International Covenant on Civil and Political Rights. It says, "We undertake to respect and to ensure to all individuals within our territory and subject to our jurisdiction the rights recognised in this covenant without distinction of any kind, such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth or other status." A solemn promise like that should be honoured, and the Human Rights Act sought by the Law Council's policy would be a major advance towards honouring and giving effect to, in a thoroughgoing way, Australia's international human rights obligations arising under major instruments to which Australia is a party. The ACT, Victoria and Queensland have paved the way. National legislation to give effect to Australia's international obligations can draw upon, but not be limited by, this experience gained in these domestic jurisdictions and other jurisdictions around the world. The Law Council's refreshed policy covers the following 8 areas, and I'll say a few words about each of them in turn. They are the rights to be protected, who should receive protection, the importance of an interpretive clause, statements of compatibility, duties on public authorities, an independent right of action, remedies, and procedural matters, including costs. So, the rights to be protected. As we now have experience of human rights legislation operating in Australian jurisdictions, the policy looks to broader sources of rights to be protected, and not just the civil and political rights in the ICCPR. Greater recourse is urged to the economic and social rights, the rights of people with disability, the rights of children as identified in the more specialised international conventions, and the rights of older persons. Who should receive protection? It seems fairly uncontroversial that human rights protect the rights of human beings, not those of corporations. But that doesn't mean that a tradesperson who conducts their business using a trade or a trust or corporate structure would not receive protection from an egregious assault on their rights. The importance of an interpretive clause. General legislative provisions have the potential to operate unfairly when applied to specific fact situations. This is something that the general law is conscious of and against which it seeks to guard. A provision in a human rights statute that instructs the courts, as far as reasonably possible, to interpret all legislation, past and future, in a manner that's consistent with, or most consistent with, human rights, will strengthen the ability of courts to avoid unjust applications of the law. Statements of compatibility. The requirement that draft legislation be accompanied by statements of compatibility, if implemented in good spirit, is likely to lead to legislation that is better considered and ultimately better legislation. Parliaments are required as part of regulating society to limit the exercise of various human rights. Indeed, laws restrict human rights to protect human rights. A statement of compatibility process, especially when combined with strong parliamentary committee processes, is directed to ensure that the drafters of such legislation use a human rights focus to give consideration to the precise objectives being pursued and to whether those objectives can be achieved in a different way with less draconian impacts on people's human rights. Ultimately, statements of compatibility seek to ensure that the legislation passed by our parliaments represents the best possible version of that legislation, especially from a human rights point of view. So, duties on public authorities. A Human Rights Act should include explicit duties on public authorities to act compatibly with human rights and to give proper consideration to human rights in the development of policy and the making of decisions. In the Law Council's view, this is one of the most beneficial roles of human rights legislation. It's not doubted that public servants and public service agencies are dedicated to excellent and just administration. But a duty to consider and comply with human rights provides a touchstone against which every decision in practice can be measured. It also allows members of the public and advocates for vulnerable people a reference point by which questionable decisions and practices can be called into question, and the presence of an enforceable duty on public authorities focuses the mind. So, an independent, direct right of action. This shouldn't be controversial, but in some states, well, Queensland, they went with the so-called piggyback provision, such that a human rights basis for relief can only be pursued if a general law basis is also being pursued. That doesn't make a lot of sense to me and may add unnecessary complexity to some litigation. The experience with human rights-based litigation around the world is that floodgates fears have not been warranted in practice. The Law Council believes that barriers to raising human rights concerns in court should be minimised so that vulnerable people are not prevented from seeking a remedy for what they see as injustices. The ACT Human Rights Act at Section 40C provides for a standalone right to sue for breaches of one's human rights under that legislation. The Law Council supports that approach. So on to remedies. The Law Council considers that in every case, an effective remedy should be available to provide appropriate and adequate reparation for the injustice suffered. Some jurisdictions have been cautious and, for example, have ruled out money damages as an available remedy. It's true that righting the wrong with a declaration and/or an injunction will be sufficient in many cases, but there'll be other cases where a complainant has suffered greatly and many years of their life have been affected. They should not be denied monetary compensation. And finally, procedural matters, costs. Costs regimes in human rights legislation raise several competing considerations. On the one hand, the threat of losing one's house and other assets because of losing a meritorious case will inhibit people's willingness to pursue their rights. On the other hand, the availability of a favourable costs order for a successful applicant will allow actions to be brought with the assistance of lawyers who are prepared to take a risk. The Law Council recommends a variety of approaches, including a less stringent costs follow the event rule to protect unsuccessful applicants. The availability of protective costs orders made early in the proceedings, which allow applicants to know that they won't be saddled with a horrendous legal bill involving the cost of 3 government senior counsel, and an ability for successful applicants to receive compensation for the costs they've incurred in bringing the litigation. Naysayers will claim that there are considerable negatives for enacting a Federal Human Rights Act. Cost for taxpayers for one, or pressures on an already stretched court system for another. However, the Law Council doesn't consider that their experience to date bears this out. Reviews of existing state and territory human rights acts indicate that rather than resulting in a lawyer's picnic, the benefits often lie outside court proceedings and that human rights are considered by the executive and the legislature early in their processes. It may, in fact, be costly for taxpayers not to promote human rights protection. For instance, it's estimated that the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability cost $527 million. I mention that a Federal Human Rights Act will not cure all ills, but when we're being asked to tighten our fiscal belts, perhaps more cost-effective preventative solutions are what we should be looking for, resulting in less personal heartache to many groups of Australians. Let's look at what is working at the moment. Of the 2 states and 1 territory that have a Charter of Human Rights, reviews indicate that the courts in the ACT and Victoria have not been flooded with litigation. Instead, there's been improved parliamentary and bureaucratic cultures of respect for human rights in a preventative sense. The 5-year review of the ACT Act found its main effect had been on the legislature and the executive, fostering a lively human rights culture within government, leading to human rights concerns being given due consideration in the framing of new legislation and policy. These improved laws are likely to have tangible benefits over the longer term, particularly in the form of additional safeguards for vulnerable individuals in the community. Meanwhile, in Victoria, the Charter has played a critical role in preventing or curbing many human rights breaches and their associated social and economic costs. The experience of jurisdictions with human rights acts in place indicate that these have led to tangible and practical improvements in the way that people's rights are upheld in practice. For example, this included a better outcome for a 40-year-old man with disability living in aged care. His grandparents communicated his charter rights to the Transport Accident Commission, who accepted responsibility for its failure to respond to an opportunity to assist him to live in a more appropriate care facility within a specified timeframe. It revisited its decision and recognised the need to uphold his rights. Those kinds of experiences underline the potential of a Federal Human Rights Act in driving government-wide culture of respect for human rights. But, I hear you ask, will legislating rights and freedoms help ensure that all persons are treated fairly and equally, with dignity and respect? I would suggest that few Australians would know the reality about the lack of protection of their human rights. And it's difficult for people to defend their rights when they know little about them in the first place. For human rights to matter in practice, they must be incorporated in the education and practice of everyone in the Australian community. This includes, for example, teachers, the police, health, disability and aged care providers, prison and detention facility operators, business leaders and the media. The Law Council is also concerned that there's a lack of human rights engagement and training across public departments and processes more generally. And this may result in human rights not being properly considered when cabinet decisions are made, laws are designed, and policies and programs are implemented. Too often, human rights compatibility statements, which are often lacking in substance and quality, are tacked on at the end of the process rather than being baked in at the outset. This lack of early consideration may mean that the needs of diverse groups of Australians are consistently being overlooked. One recent example, provided in evidence given to the recent Royal Commission, was that people living with disability were not mentioned in the Australian government's original pandemic emergency health plan. While this was later rectified, it was an extraordinary omission. Human rights should never be an afterthought. They should be part of the democratic recipe. A well-drafted Federal Human Rights Act would, in the Law Council's view, help ensure that the needs and circumstances of the full, diverse range of Australians are better understood and reflected in policy and program design upfront, whether in emergencies or otherwise. The Law Council considers it important to examine legal structures which can ensure that the principle of universal design is built into mainstream policy and law development. The idea is to design products, environments, programs and services to be usable by all people to the greatest extent possible, without the need for adaptation or specialised design, including assistive devices for particular groups of people with disabilities where required. This is where a Federal Human Rights Act has a role to play, along with an anti-discrimination law framework. A well-drafted Federal Human Rights Act would embed a general and fundamental understanding across the Australian community that people living with disability are people of equal dignity and worth, whose rights must be respected, protected and fulfilled alongside all others. In practice, this would give a Human Rights Act the role of requiring public authorities to assess their actions according to human rights standards, and would be likely to lead to an improved national culture of respect for the human rights of people living with disability. A Federal Human Rights Act would be a powerful tool to build the edifice of Australia's international human rights obligations. It would ensure that the decisions and actions of our governments are guided by the time-honoured values of freedom, equality, justice, compassion and dignity. It will help everyone, from school children to recent arrivals, to understand the rights and freedoms that we all share and to place a premium on them for our future. It will mean that questions of human dignity are taken into account when they matter most. We're at a turning point in Australian history as we look past 2020. Now is the time for conversations between the Australian people and their governments. What kind of future do we envisage for future generations? How can we be a prosperous and a just and fair community? A Federal Human Rights Act may not be a complete answer, but it's a start. So I ask this question: what are we afraid of? Thank you.